Hi everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about what to know if your deceased loved one owned firearms. Well, according to the Bureau of Alcohol, Tobacco, and Firearms and Explosives, the ATV, from 1986 through 2018, tens of millions of firearms were both manufactured in and imported into the United States. Now, lots of those guns are filling gun safes and closets and nightstands and desk drawers in homes all across this country. And regardless of whether you think it's a good thing or not, the fact remains that firearm ownership is very common in America. And when you're handling a deceased loved one's affairs, you must consider the chance that your loved one owned one or more firearms at the time of their death. Now, consider the following scenario. Your widower father just passed away, and after making arrangements with the funeral home, you let yourself into his home to pull together some photos and other memorabilia to display at the funeral. As you're going through his closet, you discover a dozen guns on the top shelf. Some of them are obviously hunting rifles, revolvers, and standard shotguns, but some of them appear to be military-style firearms with pistol grips and mounting rails, and one of them even has a three-way selector switch near the trigger. What should you do at this point? Although there are many things to consider in a situation like this, here are a few things to keep in mind as you deal with firearms owned by a deceased loved one. Determine who has legal authority to handle the firearms. In a scenario such as the one that I just described, you should first determine whether your deceased father had a will or a trust in which he named someone to be in charge of his final affairs. If he did, you must find those documents as soon as possible and determine who is named the executor or the personal representative under his will or the trustee of his trust. If that individual is not you, you want to contact the person and let them know about the existence of the firearms and encourage the executor or trustee to take the appropriate steps to safeguard them. If you're the person nominated in the estate documents, determine whether or not the firearms were ever transferred to the trust by the trust maker or are owned only in the name of the loved one. In many trust-based estate plans, the trust maker signs an assignment of personal property, a document that transfers ownership of personal property, including firearms, to the trust. If you find an assignment missing, or if you find an assignment amongst the trust documents and it appears from the language that the trust maker intended that the firearms be owned by the trust, you will typically have the legal authority to take possession of the firearms for safekeeping and for later. Next, you want to secure the firearms. If the firearms are not already secured in a strong gun safe that cannot be carted away in a burglary, make arrangements to properly secure them as soon as possible, particularly when they are in an unoccupied residence. Burglaries happen every day, and an obviously unoccupied house or apartment can draw the attention of would-be burglars. If unsecured guns are in the house, their theft could ultimately lead to commission of a violent crime. In that event, victims could sue for civil damages or even criminal liability against the person who is responsible but failed to properly secure the firearms. If you think that keeping guns in a safe in an unoccupied residence is still too risky, and it may well be, consider placing the guns in the custody of an individual or entity that holds a federal firearms license, FFL, until you can determine whether and how to distribute the firearms to the heirs or the beneficiaries. Someone with a federal firearms license can legally take possession of a wide variety of firearms, including guns that are not typical hunting rifles or pistols and shotguns, such as machine guns and short barrel rifles and shotguns, and accessories such as silencers, the possession and transfer of which are subject to even more restrictive laws. Now, the federal license, you will have the proper authority to possess the guns and perform necessary background checks before any transfers take place. The licensee will probably also have proper storage and insurance that will protect the executor or the trustee from any liability should something happen to the firearms during the course of the estate or trust administration. You can look up local firearm licensees through websites such as fflgundealers.net and gunbroker.com. to learn more about how they can help you stay out of legal trouble when selling or otherwise transferring those firearms. Now, prohibited persons cannot legally possess firearms. Beyond safely storing and transferring the firearms, it is important to remember that even though you or another family member is nominated in your loved one's estate planning documents to handle the deceased final affairs, it may still be illegal for you to take possession of those firearms, even to transfer them to somebody with a federal license. Federal law restricts certain individuals from possessing a firearm in any situation, even if that person is acting as a fiduciary of an estate or a trust that owns the firearms. Under federal law, prohibited persons include anyone who has been convicted by any court of a crime punishable by imprisonment for a term exceeding 1 year, anyone who's a fugitive from justice, is an unlawful user of or addicted to any controlled substances, including marijuana, even if it's legal in the state where you live. Anyone who's been adjudicated as being mentally defective or committed to any mental institutions. Anyone who's an illegal alien or has been dishonorably discharged from the armed forces, has renounced U.S. citizenship, or is subject to court order restraining the person from harassing or stalking or threatening an intimate partner or the child of an intimate partner, or has been convicted of a misdemeanor and a crime of domestic violence. In some cases, state laws can even be more restrictive than the federal law described above. You just want to consult with an attorney who's an expert in not only federal laws, but also your state's laws regarding possession and transfer of firearms. If your deceased loved one names someone to be in charge of the firearms or to ultimately inherit them, the named person must be able to qualify to possess a firearm under both federal and state laws. If an executor or trustee takes possession of or transfers firearms to someone who is not legally permitted to possess them, stiff penalties may apply, including up to 10 years imprisonment. Once you've determined who can lawfully possess your loved one's firearms, look to an existing estate documents to determine who they should be distributed. Arrangements can be made to deliver those specific items to the individuals named to receive them. You want to obtain proper valuation of the firearms. If your loved one died without a will or a trust or without otherwise specifying in estate documents who would receive the firearms should be appraised by a valuation professional. The firearms can vary widely in value depending on a variety of factors, including their condition, their rarity, and the nature of the modifications that have been made to them. Therefore, looking up what appears to be a similar gun on a website may provide a significantly inaccurate estimate of the gun's value. So don't attempt to value the firearm on your own. Enlist an appraiser with significant experience in appraising firearms to help you with this task. Appraisers can often be found at reputable pawn shops, gun stores, auction houses, and online. Be careful when choosing an appraiser. Not all appraisers are qualified to value firearms, and some less reputable appraisers may even attempt to minimize the value of the firearms in an effort to profit from your inexperience in handling such specialized items of property. Ask around at local gun shops and even check with local law enforcement to identify reputable gunsmiths or appraisers who can assist you with this task. Once you have properly appraised the firearms and it is time to either transfer them to an heir or to sell them, the most conservative course of action is to arrange the transfer by working with a business or an individual who holds that federal firearm license. Depending on the state where the guns are located, the FFL licensee will be qualified to perform any required background checks, registration requirements, or bills of sale for the individuals who are purchasing the firearms or receiving them through the terms of the will, the trust, or inheritance laws under state law. If you choose not to use an intermediary with a federal firearm license, you should at minimum get a signed, notarized statement from the individual to whom you're transferring the firearm that the recipient is not a prohibited person under either state or federal law and can legally possess a firearm. There may also be additional requirements in your state for transferring these firearms. There are different classifications of firearms, some with even stricter legal requirements for ownership. Thus, it's crucial that you consult a qualified attorney in your state before making any transfer of a firearm. Let's talk about crossing state lines. If your deceased loved one lived in another state and you're responsible for handling the deceased final affairs, exercise great caution when transporting any firearms across state lines. Because state firearm laws vary widely, it is even more important to obtain sound legal counsel before transferring guns to someone who lives in another state. In such a case, it is best to work with a federal licensee who lives in the state where the firearms are currently located and who can take possession of the firearms and handle any future transfers of those items. Be aware that when you place firearms in the care of a federal licensee, the protocols that apply to a transfer to any third party also apply to returning the guns to you, including any mandatory waiting periods. Let's talk about surrendering firearms to law enforcement. Today, many people have determined that they have no use for firearms and they desire to decrease the number of existing firearms in the world. If none of the estate's heirs want to inherit the firearms and no family member wants them to be sold for cash to be distributed to the heirs, consider surrendering the firearms to the local police department. By doing so, you can avoid the requirements and potential liabilities associated with transferring firearms to private buyers. This option may even make more sense if the firearms values are too low to justify the effort required to safely and legally sell or otherwise transfer them. If surrendering the weapons to law enforcement makes sense to you, contact your local police department and explain the situation and ask them how to go about it. Many families have enjoyed hunting, recreational, or competitive shooting and collecting guns for generations. As a result, firearms can have significant meaning and sentimental value. But as you can see from the discussions that I've just had with you, transferring firearms to the next generation or selling them to third parties, it requires great caution. The laws surrounding firearms are many and complex. If you find yourself responsible for handling the distribution or safekeeping of a deceased loved one's firearms, your best course of action is to get help from an experienced gun law attorney or a gun dealer. So I want to thank you for listening. I hope you found that beneficial. I'm Kelly Longtin from Kelly Longtin Law.